Hello, friends of truth, justice, and the American way. I'll be in court this morning on RIPP v. Town of Oyster Bay, Index 1834 of 217. I'm currently fighting to have the town attorney held in contempt of court. What you see in front of you here is the complete file for the action. It started out back in 2017 when I filed an order to show cause seeking declaratory and emergency injunctive relief through an Article 78. I got a restraining order against the town. Actually, the town had Deputy Town Attorney Frank Scalera show up for this. We are arguing a number of times orally. I prevailed in every instance. Initially, I got an order against the town preventing them from paying out in their sidewalk scam, where they were paying a contractor $400 for every $100 that they were charging residents and borrowing the money to do so. After that, the town filed a notice of appeal. They never perfected their notice of appeal. And I then filed a motion to hold them in contempt. Step back real quick. There were a couple of other outcomes from the initial Article 78. The town board earned the distinction of being the first town board in the history of the state of New York to be ordered to remedial open meetings law training. And that's part of the contempt hearing now. They were ordered to produce a certified attendance record, and they refused to do so. The second part of the contempt action has to do with my Freedom of Information request. And this has really created a real big stir in Oyster Bay. To begin with, as I mentioned, the town was ordered to remedial, or the town board was ordered to remedial open meetings law training, public officers law training. And recently the town clerk has come forward and made admissions that the town attorney had been circumventing the authority of the town clerk by diverting FOIL requests, such as my own, from the authority of the town clerk, and the town attorney was deciding what information they wanted to release to the public. So you weren't really getting public information, you were getting what the town attorney wanted the public to get. And in my personal instance, there was majority or some material that they sent me that they never billed me for. So, like, to me, this is indicative that the town attorney knew that they were doing something wrong, but they were trying to prevent the paper trail by not billing for things. All right. Eventually, through my order to show cause, my motion to hold the town in contempt, the town was ordered to produce the FOIL material by October 3rd. And if you don't know, what happened is the town attorney set everything up. They circumvented the authority of the town clerk. They presented the material to me as if it was coming from the town clerk, but none of it contained any of the proper authorizations, the certifications. You know, that's the town clerk fills them out, and the town has a seal on everything. They certify documents as complete, true, and accurate. So where we're at now, I don't want to ramble on too much. Where we're at now is I filed this motion to hold the town in contempt back in July. Been in court a couple of times. The Honorable Jeffrey S. Brown, in my opinion, he's bending over backwards not to hold the town in contempt. For instance, he produces an order in August ordering the town to provide a certified statement of attendance, and Deputy Town Attorney Matt Rosea responds in writing and says, we don't want to do that. Take my word for it. I'm telling you that everybody attended. Now this is after the same Deputy Town Attorney, as an officer of the court, swore that the video that he had turned into court of the remedial training was going to substantiate the attendance of these officials. And in the same August of 2018 order, Judge Brown acknowledged that it didn't. So, I don't understand why Judge Brown would take this man for his word after he demonstrated that it's not worth much. But that's where we're at with remedial training. I'm still arguing that, and I'm going to appeal that if Judge Brown eventually rules in the town's favor on that. Now, the rest of the contempt of court is basically based on the freedom of information. Now, the elements in the contempt of court, all right, this is a civil contempt. First, it must be determined that a lawful order of the court clearly expressing an unequivocal mandate was in effect. We have that. Second, it must appear the reasonable certainty that the order has been disobeyed. Now we have that. Third, the party to be held in contempt must have had actual knowledge of the court's order. All right, we got that. And fourth, prejudice to the right of a party to the litigation must be demonstrated. Now, it's pretty clear that by the town attorney circumventing the New York state law and withholding the public information from me, they're prejudicing me to my right. All right, I have a constitutional right to that public information. The town attorney doesn't want to give it. Now, tomorrow when I go into court, this gets where it starts to get interesting. First of all, this is a little strange. This is a letter from town attorney Matt Rosea. It's to the court, and he recognizes that it says, I'm receiving Your Honor's August 28 order, which held any determination of contempt in abeyance pending compliance. All right, so they recognize that they're pending compliance. Now, in the last hearing, I brought up the issue that the town was failing to purge themselves. And Judge Brown tried to say that there was no purging going on, but these are just some notes from previous hearings, because I have all the transcripts. All right? Like, the court is Judge Brown. Let me say one thing. This may help things out. Even though you've asked for contempt, the town has an absolute right to purge themselves in a contempt by providing whatever was directed in the order. So what I'm saying is, if the town does that, they won't be held in contempt. All right, then that was on July 30th, 2018, right? And October 4th, Judge Brown says, I don't want him to get a sea of papers. I want him to have it the way the open meetings law requires. And I say, why don't you follow the procedure of the New York State Town Code and have it at the town clerk contact me? That's the law. The town clerk's supposed to do it. The clerk's supposed to produce all the FOIL material. And then Judge Brown also said, and I'm directing that they do it exactly like I said, no ifs, ands, or buts. Okay, so therefore there is really nothing for me to do now because they have an absolute right to purge themselves of any contempt. And I'm not about to do anything that's not within the confines of the law. And then Judge Brown further says, you have to understand, Mr. Ripp, Mr. Rosea is right. They have a right to purge themselves of contempt, and I will make that determination. As of now, I think they have purged themselves with respect to the first part. Now, he's speaking about the attendance at the remedial training. All you have is Matt Rosea's word that they were there. That's it. And Rosea's already demonstrated that his word's not good. Now, for the second part, that's the FOIL material. So, Judge Brown gave them till October 3rd to produce the material for me. Okay, it says it here in Rosea's letter. All right, on or before October 3rd. Now, we were in court November 1st, and it was demonstrated that the town clerk made admissions during the October 16th, 2018 town hall meeting that the town attorney was circumventing his authority, and there was a big blowout during the town meeting over it. So this was all produced to Judge Brown in our November 1st hearing. So it's clear this is where the subject of purging came up, because I tried to make a point that the town had failed to purge themselves, and Judge Brown started backpedaling that there was no purging. Obviously there was. He's mentioned it in more than one transcript. Right, now to get on to tomorrow, or today actually, this morning. I don't think the town attorney is aware that I have this information. What happened was, when I found out that the material that I received from the town, I went and I reviewed the court-ordered material, and I purchased some of it, and I knew some of it. I purchased it on purpose because I knew that it wasn't complete and accurate, because I had already done FOIL material for some of the documents in the past, so I could tell if the town attorney was releasing all the records to me, and they didn't. All right, so after I went to court on November 1st, what I did is I returned all the material that I purchased. It was $36 worth, and I asked the town clerk to prepare a resolution for a refund. That's the way it's done. And the town clerk agreed to do it. Okay, so now, though, I got this letter just recently, like I think it was the 3rd I got it. It's dated the 1st. And it says, this is from the town clerk, James Altadonna, and it says, Mr. Ripp, this is a very difficult time to be an elected official in the town of Oyster Bay. However, I believe it's the most important time to be an elected official. I feel strongly that you or any resident are deserving of a refund in this case. Having put forth the refund request on November 19, 2018, only to have it returned to me on November 28, 2018 with a verbal opinion from the town attorney, of which I do not agree. Therefore, it is my obligation to personally refund the monies to you. Enclosed, please find my check for $36. Now, this is just amazing because the town clerk is admitting that the court-ordered FOIL material wasn't produced correctly. I deserve a refund for it. The town attorney doesn't want to give me a refund. The town clerk, realizing that this is wrong, wants to provide me with a refund from his own pocket. I appreciate that, but that's not the way it works. I think what's going to happen now is after court today, this will be discussed in court, okay? And I think it's going to be pretty much, clear proof that the town attorney has no plans in near sight or at all to follow the order of Judge Brown and to come in compliance and purge themselves. All right, I don't think they're going to remain in contempt. All right, the material has to be produced accurately, completely, true copies through the office of the town clerk, and the town attorney just refuses to do that. So we'll find out. In court today, we'll find out exactly where Judge Brown stands now. I don't think he's going to be able to hold off any longer on finding the town in contempt. I'm sure he'll do his best because, I really believe that because this is a politically motivated action, the town is getting a lot of leeway that a regular person wouldn't get. So, in any case, I'll follow up after I get out of court. Thanks for following. Semper Fi.